Hello again, everyone, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley. Thanks again for joining. And in the spirit of kind of just having a little more organizational flow to the podcasts, we're going to stick with parenting. So as you know, we started the year out, and January was really a lot about just getting motivated, doing something, taking those steps to get forward, to move forward, whether it's in a divorce process or getting into some kind of something to work on your marriage, but just really doing something, taking those steps, getting out of that mode of paralysis and moving forward. So here we are. We're now in February, and one of the things that we've started is to talk about is really what I think is most important when you get into a divorce is what do you do with the children? So in the first episode, we talked about parenting time, and that really is the foundational piece in a parenting agreement is where are the kids going to reside, what's the schedule, let's get that situated. Now, the bigger issue once you get the schedule to complete your allocation judgment, which is what we used to refer to as a parenting agreement or a joint parenting agreement, is the decision-making authority and whether or not that can be agreed upon, or if not, what does the court look at in determining who's going to be making decisions for the children. So most of us historically understood this to be custody. We don't use that nomenclature here in Illinois anymore. There is the determination and the allocation of parenting time, and then separately from that, but within the same agreement, is the allocation of decision-making authority. So backing it up, what are we really talking about? When you're talking about custody in the old days or allocation of decision-making authority now, we're really talking about a couple of, really limited but important buckets, okay? We're talking about education. We're talking about religious upbringing, if that's an issue in your family. We're certainly talking about medical care, and subsumed in all this, too, is also activities and the decision-making and authority to select activities and so forth. So let's break that down a little bit, right? When we talk about those areas, we say education can be very broad. And if you have a family that is able to agree that as part of the finalization of the divorce, they will jointly decide educational decisions, we're talking about major decisions. What does that mean? Well, if one of the parents has the children after school on a given night, and the child has questions of mom or dad about the homework, for example, that's not something where one parent's going to be expected to reach out to the other and what do you think about how should we approach this assignment with them? No. Those are real-time, in-the-moment decisions that any parent would make. What we're really talking about is the major decisions, all right? So if we're talking about education, let's just start there. Where's the child going to go to school, okay? Do we have an agreement during the divorce that the child is going to go to the public school in one parent's district versus the other? Is there a conversation or an agreement around the possibility of a private school? And then you get into a whole different issue when you have a private school is if the child hasn't yet been enrolled in a school. Say it's a young child and maybe you've just got some daycare options and you really haven't gotten to the point where you've had to decide are they going to go to a public school or a private school. There's the question as to whether or not the court has the legal authority to mandate private school. So if the parties agree upon that, and there's a cost to private school, and certainly here in Chicago, there's a huge cost to that. If you want a private school education for your children, you are going to pay handsomely. And so if someone's going to foot the bill for a $30,000 bill, could be more, could be a little less, who's paying for that? That has to be part of that conversation. Typically what you see is if there is an agreement to designate one parent as the primary parent, then, as a default, the children will go to the public school in the district where the primary parent resides. Oftentimes, when the kids are already in school, parents try, and they should, try to keep the kids in the school that they've been in. for the continuity and the consistency for the kids, that's important. Well, one parent may be moving out of the district. It could be next, community next door, so you're still close enough to have a good parenting arrangement, but maybe that community next door, the public schools aren't as good. Maybe they're better, and so the parents decide jointly to have the other parents, be the custodial parent as it relates to education so they can enroll in that district. So that's an example of a major educational decision. Sometimes you get into whether or not a child needs special services, and that sometimes can be quasi-medical and education at the same time. Do they have an IEP? Do they have an educational plan? Is that something that the evaluations and the testing that's done for that, does one parent or the other have the legal authority to implement that? The majority of the cases we settle, it's with a joint legal decision-making and the authority to both make those decisions. What does that mean? So, for example, again, on the education piece, let's say there's a child that seems to be struggling in school. One parent seems to think that, hey, we should have the other, the child tested and maybe have some sort of psychiatric evaluation. Maybe there's dyslexia. Maybe there's ADD or ADHD, something that's compromising or inhibiting the educational abilities of that child. Maybe the other parent says, I agree or disagree, but there's a recommendation for Ritalin, for example, some kind of medication to address. And one parent agrees, one parent doesn't. What happens in that situation? Well, if one parent has the legal decision-making authority, the sole decision-making authority, that parent gets to make that decision. So it's a very big deal when you're talking about a child's education, also child's medical care. Some people parents of the same child don't always agree upon medications or vaccinations. That was a big thing. We all lived through that through COVID. Had a lot of cases. We even had judges who were, making determinations about parenting time based upon one parent's position with respect to vaccinating a child. And it became a hotly contested issue. And then research rolls out over time, and you see the impact on children. Is it good to have children vaccinated? Was COVID impacting children? A lot of people saw that differently. And you had parents in the same household that did not agree upon that. And so it was a very real medical issue, which we'll get into, but that also impacted certain schools, right? If kids weren't vaccinated, they had to do special procedures at universities. So sometimes there's that overlap of schools and medical, but at the end of the day, there can be some really serious decisions that we as parents have to make on behalf of the children. And that's where your opportunity to be involved in those decisions is when the case begins, right? If you say, well, my spouse has kind of made those decisions, I don't really care, he or she can have sole decision-making authority, and then all of a sudden there's a very serious decision that needs to be made, and you've given up the legal authority to do that, you may not have much you can do or say about that. So think about that, and again, this is in the context of sort of building on how we've started the year. You've gotten up. You've said, I can't do this anymore. The marriage is irretrievably broken. I called Quigley. I built a strategy. We got him retained. He's my lawyer. He put his team together. And now we're focusing on the first things first, which is, what are we going to do with the kids? We got a schedule ironed out. Great, terrific. Now we're talking about these very important decision-making. And is it something that, is it worth fighting over? Is it worth spending money, litigating over? And again, this is a very individualized, I think, decision for parents. But again, if you let go of certain rights now, you're not going to get them back absent something, really significant happening to change the circumstances. So if you have situations where you're concerned about your children's educational upbringing, you may want to make sure that you and your legal team advocate for you having at least joint decision-making. We talked about school, that being one of them. I'd argue probably the most important major decision that people have in an allocation judgment is medical decision-making. And again, we kind of talked about that in the context of, maybe medications for ADD or ADHD. Sometimes there could be medications for depression or anxiety. Do you medicate your children? Do you not? That can have an impact on their education, but it certainly can have an impact on their health. So that's an issue a lot where we see that. And like I said, with the vaccines, that was a big deal for quite a while. Historically, when you dealt with medical, when you're talking major medical decisions, you're not talking about, hey, the kids are with me, and for the 2 days or 3 days I've had them, we're running a fever and the fever's high. I need to take the child into the pediatrician. You don't have to get permission to do that, even if the other parent has sole decision-making authority. The day-to-day care for children is presumed to be within the control of the parent who has the physical control. You have to take care of things real time, right? Child is with a parent and an accident occurs. You don't have to wait to get permission to call the ambulance, to take them to the emergency room. You do that stuff. That's real time. We're talking more about a situation, say, for example, a young child, God forbid, has a very serious diagnosis. Whether it's, I have a good friend of mine whose child, when he was very young, was diagnosed with diabetes. My friend and his wife had to really make some decisions as it related to some of the, procedures and medications that were available at the time. Very stressful time, something they were on board together with. But again, that's something where you want to make sure as a parent you have the right to at least, maybe you want to get a second opinion. Not that you don't trust your pediatrician, but what's being recommended, a surgery, a procedure of something that, it could have some very long-term consequences for your child. You would rightfully want to be able to have a second opinion and check the checkables and maybe find out and do some research and see other alternatives. These are the type of things that, again, in your divorce, in an allocation judgment, you have to spell out that you as a parent have the legal authority to jointly decide those so that one parent cannot unilaterally go and make the decision. If you agree to the other parent being able to unilaterally make those sole decisions, they can do that, and you might regret that later. If you don't agree and you go to a trial and a court awards one parent or the other legal decision-making on a sole basis, meaning they don't have to consult with the other parent, they don't have to get the other parent's agreement, that's something they have the right to do. So if you're hearing this and you're thinking, wow, of course I'd want to be involved in the major decisions that will affect my children, and there may not be that many throughout their lives, right? God bless you if you don't ever face a major medical decision. We hope that for every parent. And same with school. Hopefully your child tracks through school, you guys agree upon the school. You never really have to enforce these agreements, but they're in place to protect your rights as a parent, and it's important. Whether you need them or not, you want to advocate for them now. So we talked about school, we talked about medical. As I mentioned before, sometimes you have families with different religious backgrounds. And I had a client who was Catholic, his wife was Jewish. They raised their children kind of non-denominational. It wasn't a real big part of any disputes while they were married, but then once they got divorced, it became a big deal. Obviously, fundamentally different beliefs, the traditions, the cultural events around each particular religion were different, and each side all of a sudden kind of were very passionate about that. So if one parent had sole decision-making, they could say the child is only going to be raised Catholic. And the Jewish parent had no rights. Or if they agreed to do things jointly, then they got to figure it out, like they did while they were married. Maybe there's going to be a bat mitzvah or bar mitzvah. Maybe we're going to have the sacraments for the child, maybe not. You know, are we going to celebrate the Jewish holidays and also celebrate the Christian holidays? Well, if you have joint legal decision-making, those are the things that you have to agree upon. And by and large, you don't see a lot of religious disputes, but that can be a major, major issue. So be aware of that heading into this. And of course, then the decision-making as it relates to activities. You know, activities, as your children get older, when they're little, it kind of seems like, oh, this is fun. We, you know, go to the soccer game on Saturday morning, you know, and then all of a sudden Little League, and now all of a sudden we're doing travel sports, and, you know, it's pandemonium. So I always tell people, having raised 4 kids of my own, and your weekends are not your own, wouldn't matter if you're married or divorced, you got to figure things out, because you are all over the place. You need to work together just to make sure this kid gets to that tournament and this one's, you know, to that game, and so on and so forth. So, but you can't always have, especially where there's acrimony between the parties, 2 different people signing up the kids for this and this and that, and we're on different schedules. Logistically, that can't work. So that often becomes something that, you know, sometimes even with respect to joint decisions, you know, sometimes they have agreements where parents are able to select activities, you know, during this season, then the other parent gets that season. Or oftentimes what the orders look to is, what are the kids in currently? And the expectation is that they will continue in those activities, and unless the children don't want to do that and they want to switch. So you always kind of want to involve the kids maybe in that piece, whereas kids don't necessarily decide their educational future, their medical future. You know, if they like basketball instead of, you know, hockey, they're going to make that decision, and parents hopefully can agree upon those things. So structurally, those are the buckets that, when you talk about allocation of decision-making authority, again, which we used to refer to as custody, that's really the world of what you're deciding. A lot of that stuff is predetermined, and so people come in and they're fighting about stuff, but your kids are already in high school. You know, they're not going to change schools. You understand they're tracking a particular way. You have no legal decision-making in terms of the selection of their college, because they're going to be 18. You can limit the amount you're obligated to pay for their educational expenses in Illinois up to the equivalent cost of the University of Illinois, Champaign-Urbana, in in-state tuition, room and board. But beyond that, you know, you're done. So, you know, the kids are in school. The kids have, thank God, they've been healthy. And, you know, barring anything really significant, they're going to go on and they're going to go to college and they're going to continue to be healthy. Religion's not an issue. Where's the fight? You know, so again, where your children are at in their lives is oftentimes going to drive that conversation. If you've got young kids, haven't even decided school, haven't decided activities and those kinds of things, it might be a much more important conversation to have. But in any case, it's a conversation you need to have up front. Again, I always say, it's not that the money issues are not important, they are. And we'll get into those in subsequent episodes. But really, when you're talking about children, getting them safe, getting them secure, making sure mom and dad are in agreement, or mom and mom, or dad and dad, or whatever your arrangement is, that the parents of children are at least have a plan moving forward in terms of how these major decisions are going to be made. Because that's where we find a lot of litigation, is where you need to make a decision and one parent doesn't, and they're holding up a process. So oftentimes we put in clauses that say, number one, if the parties can't agree, we're going to defer to, what did the pediatrician recommend? Okay? And then if one party doesn't agree with the pediatrician's recommendation, they have X number of days to get a second opinion. You know, if it's something life-threatening, then a decision has to be made and we're going to follow the pediatrician's advice. So timing is an issue in making decisions, right? We don't have the luxury sometimes with our children to sit and kind of ponder things. That we have to make decisions because it can affect their future. So putting in appropriate provisions into an allocation agreement or allocation judgment is really, really important, Because if you don't have the ground rules and then you find yourself saying, gee, I think we should enroll the child here, and enrollment's only open for another week, are you going to be able to get into court on an emergency basis? Is a court going to be able to have sufficient facts or evidence to be able to make that decision in a week's time? Probably not. So you want to think about those things in advance. You want to have them in writing, again, all with hopes that you never need to look at it, okay? What we do in every allocation judgment also is we build in some sort of dispute resolution clause. What does that mean? Well, it means if you're going to go into an agreement where the two of you at least were able to agree that that's what's best for your children, that the two of you will make decisions together. Okay, well, that's something to build upon, right? That's an agreement that you guys have already started with, and I think that's something that's an important starting point, because if you guys as parents can't even agree upon the fact that one of us should make the decisions or both of us should make it the decisions together, and by the way, we can't agree that the sun is shining today even though it's a beautiful sunny day, you're going to have problems. And so those are the cases we look at and say, number one, is it really in the children's best interest to have mom and dad who can't agree upon anything? They're so oppositional to one another, to have them forced into a situation where they're expected to jointly make decisions for their children. It's not going to work. And what happens? It's like we talked about before. Decisions need to be made. People are running to court. And decisions don't get made when they should. And it just creates more acrimony, which, again, cascades down onto the children and makes their lives miserable. So having dispute resolution language in there is also important in those. Sometimes we put into agreements that there's going to be what we call a parenting coordinator, and there's statutory authority for that, which is an individual is appointed to basically resolve disputes. Now, how much authority you in an agreement give to that person is up to the parties, but at a minimum, they can call balls and strikes. They can keep people from having to go to court, which takes time, costs money, creates acrimony, and oftentimes decisions, sometimes they never get made and you miss the opportunity. So having a parenting coordinator can be helpful. But I would challenge you to think about this if you're hearing this. A lot of times there's this push to just say, let's just have joint decision making. You see this push toward 50-50, more as an appeasement to a parent, as opposed to really looking what's best for a child. And oftentimes, and I've had some really tough cases where the reality of it is what they're fighting for is peace of mind moving forward. Because if you look at your situation, and we see this with cases where one of the parents really suffers from narcissism and they have to be in control of everything. And it's not always necessarily control because they want to do what's best for the child, it's what's best for them. And the other parent looks and says, well, I'm getting pressured and manipulated and intimidated, so I'm just going to go along with it. What happens? I'll tell you what happens. You deal with it later. You're right back in court. I had a case once where that exact issue happened. The appeasement was made for the schedule 50-50, the decision-making. The next 2 years plus, we were back in court probably 6 or 7 times, over everything. The vacation time, the return of the vacation time. Could the 8th grade boy who wanted to play on the football team, could he play football? Everything was fought, everything was litigated, even whether or not the child should get a counselor. And that led to a long, drawn-out trial. A lot of money was spent. And it was pretty obvious to me that the two people that got divorced 2-3 years earlier, they couldn't see eye to eye on anything. So it was a Band-Aid. It was a temporary solution. So if you think that by appeasing your spouse and just agreeing to a 50-50 schedule, joint decision-making, and everything's going to get better because once that's entered, everybody's going to relax, I would caution you. Sometimes that actually happens. Sometimes people really have good communication. They're able to really work for the benefit of their children, and it's a tough process. You're going through a divorce. There's frustrations about one issue or another, but it's not really about what's best for the kids. But oftentimes, you have those relationships and you're getting a divorce because it's not about what's best for the kids. It's not what's best for you or even your relationship. It's about power, control, manipulation, abuse. If that is your situation, be realistic about it. Nobody wants to fight over this stuff, but at least be realistic to understand that if you just make those concessions just to make it go away, it's not going to go away. And it's just, you're going to have to deal with it, but you will be dealing with it as a divorced person. So decision-making authority on its face seems pretty straightforward. Sure, we both love our kids, we both want what's best for them, and so let's decide those things together. And that's important. As a parent, I wouldn't want to give that up. That's the welfare of your children. I mean, that's really your role as a parent, is to help guide them, make decisions for them while they are minors, right? That's why we don't let, an 8-year-old or a 12-year-old decide where they want to live or what their schedule is going to be, right? We make those decisions for them because their ability to reason through and make decisions isn't fully developed yet, right? So, but at the same time, always think about, again, we've kind of walked into this from the standpoint of this is all very new. This process is new. We're just getting this divorce started. What are we focusing on? Very early on, think about these things. And I think challenge yourself to say, what's best for my kids, really in a pure form as best you can, regardless of how you feel about your spouse. And what are you really fighting for? And what are you fighting about? And in doing that, you have to look at the history, the dynamics of your relationship. You've been married 5, 10, 20 years, and it's always gone one way. That's not going to just change because you get divorced. And if you're okay with that, and that one way has always been you and your spouse working things out, then great, right? So don't just, I guess what I'm saying is don't rubber stamp it. Have the conversation with your legal team. And you have to walk through the risk-reward of litigation. Because as I've always said, and this will be a recurring theme, I've said this in many podcast episodes in the past, litigation sucks. It's from a just even physical, emotional, mental health standpoint, it is so oppressive and can be very damaging. Beyond that, and that's just for you as the litigant, let alone your children who are already experiencing some type of trauma, right? Mom and dad aren't living together. And maybe they're relieved by it, but it still has an impact upon them. So when you layer that with litigation, and, people don't do a good job of sheltering their kids from that. Like I said before, it cascades down on them. I've had the case I mentioned to you earlier. Part of one of the deciding factors is it got to the point where the stress on the youngest child was so bad that he threatened suicide. And that woke everybody up. And thank God the judge saw what was happening, and in that case decided against the recommendation of the court's expert and against the advice of the guardian litem in the case, ruled in my client's favor and awarded him the primary physical possession of the child and the sole decision-making because the evidence supported that. These are very, very important decisions, and it's not to be taken lightly. It's something that, again, as I said, most judges, I think, would hope that you as parents do what's best for your children. And you're the ones that should raise them. You're the ones that should make decisions together. But I'm emphasizing this so that when you're thinking about the process early on, have this conversation with your team. Make the decisions that are best for your children, best for your family, and to the extent that you can, try to set your personal differences with your spouse aside. Whatever the reasons are you're getting divorced, assuming they're not related to one spouse being abusive towards children, try to work through these things as best you can. Mediation is a good option. We often send parents into mediation along those same lines saying, hey, listen, you guys figure out what's best for your family, for your children. That's what we want to promote. So, again, thinking about all this stuff in a vacuum is hard because there's a lot of other tentacles to this. There's a lot of other parts to this, which is why I always say, have a strategy, have a plan, figure out where you're trying to get for your children. What do you want for them? and then we reverse engineer, we figure out a strategy, and we make that happen. So if you have questions about your children, about your case, about decision-making within your case, always feel free to reach out to us. Again, my direct extension, 312-621-1225. My email address is jmquigley, Quigley, @beermannlaw.com. And again, happy to consult, happy to give you some direction in this stuff. And as always, thank you for following Quigley on Divorce, a behind-the-scenes look. We will see you at our next episode. Take care.